Hello, everyone. Good afternoon, and welcome to this week's Business in 2021 webinar presentation. My name is Kathy Purdy, and I'm the Marketing Manager here at Bond. Just two quick housekeeping items to go over before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and we will do our best to answer those as time permits. Once today's webinar has ended, we would appreciate you taking a moment to complete the brief survey. Your comments and suggestions are important to our panelists and provide us with topics for future presentations. It is now my pleasure to introduce today's moderator, Katie Schaefer.
Thank you, Kathy, and thank you everyone for joining us this afternoon. It is hard to believe, but we are well into year 2 of this pandemic. We are fast approaching a holiday next week, so says my calendar, and I woke up to snow on the ground this morning. But despite all that change, we still have a plethora of new legal developments to share with you. So one thing that I have been talking with a lot of clients and colleagues about recently are these various vaccine mandates that we've had on the federal front, on the state front, on the local front, and also employer mandates themselves and the legal challenges and updates on them. And so I wanted to share with you an update on the state vaccine mandate for healthcare workers. And this is something that we have covered in our prior webinars, and you must have heard a lot about it. If you've been dealing with it specifically or it reported widely in the news as well. As many of you know, there's a state Department of Health emergency regulation which required covered personnel to have their first shot of the vaccine by the end of September. The regulation allowed for certain limited medical exemptions, but made no reference to religious exemptions. The lack of a religious exemption was challenged in court, and a district court here in the Northern District of New York issued an injunction to the extent that the Department of Health could not enforce the lack of a religious exemption. That, of course, was appealed to the Second Circuit, which then vacated that injunction. And I think the decision in that case is helpful in clarifying this a bit. The state's position, which the Second Circuit agreed with, was that it was possible to not provide a religious exemption, which means allowing the person to work unvaccinated while still potentially providing a religious accommodation. And if that sounds confusing, you are not alone. That's a very fine line to be walked there, leaving many clients to be scratching their heads and wondering what exactly that means, what other possible accommodations are there if it's not an exemption. Does that mean maybe telehealth, telework, some other reassignment? Does it mean leave? What are the options there? And for many clients, I think that's going to be pretty few and far between. So I know many clients have been waiting for guidance from the Department of Health on its position and regarding enforcement. And I think we've seen a couple updates there that I wanted to share with you during this past week. So at the end of last week, the department issued a updated FAQ regarding religious exemptions. And it clarified that it still believes there is no religious exemption to its regulation. However, the regulation doesn't preclude other accommodations. So you cannot allow them to work in a covered personnel position, unvaccinated, which means, basically any position where they would have contact with patients or residents or other staff members. But you can still consider these other accommodations. So much similar to what the position it took in litigation. And just yesterday, the Department of Health issued a Dear Administrators letter clarifying at least its position in this litigation right now for us. And it said that covered entities must ensure that all covered personnel who were previously granted religious exemptions receive their first dose of the COVID vaccine or have a valid medical exemption by Monday, November 22nd. So for those folks who granted a conditional religious accommodation or religious exemption, while that litigation was pending regarding the injunction, the Department of Health has said for those folks, you have to make sure that they have received their first shot by next Monday, November 22nd. The letter also says that entities should have in place a process to consider religious accommodation requests already based on sincerely held religious beliefs. And what that signals, I think, is the guidance that you should process these requests. You need to consider them. You cannot outright deny them all. based on the regulation language itself. And that has still, well, I say clarify, but it really makes this about as clear as mud still. And it leaves a lot of questions for clients as to what to do. And I think the next steps here and what steps you take with respect to those folks you had on a religious exemption or another accommodation is going to depend on what actions you've already taken. Each in particular circumstance, the options available in your practice regarding that particular employee. The suggestion I think is going to be you need to look at it on a case-by-case basis, and please do consult legal counsel where you have questions, because this is still very complicated and it's still evolving. So the litigation we've seen so far has been on a preliminary stage based on the request for an injunction. The merits of these cases are still going to need to be played out, and that will take some time to work its way through the court system. The plaintiffs have made an application to the U.S. Supreme Court regarding the issue of injunction, so we'll see what happens there. But again, the merits are still going to need to be litigated on this, and that will be some time, I think, before we have any sort of clarity and decisions on those. But we know at least the Department of Health's position as of this point. Also remember that the emergency rule was issued on a 90-day basis. So that would expire as of November 24th, if not extended. I think many expect it will be extended, but it hasn't yet. We also have lots of questions regarding the CMS rule that was issued on the federal level, which takes a bit more of a flexible approach to those religious accommodations. There's a bit of an unanswered question on the preemption issue regarding that state regulation. Many weighing in that it does not conflict directly, but more to be seen on that. So suffices to say, this is anything but simple. It's very complicated. It's very fact specific, and certainly more to come on that front. But that is the update on the state mandate for healthcare workers. So with that background, I would like to pass it over to my colleague Nyla on the OSHA ETS update.
Thanks, Katie. Hi, everyone. So last week, I kind of extensively went over the OSHA ETS. I also wrote about it in a blog post. So the links for last week's presentation, as well as a blog post, is kind of included. In case you haven't heard, the OSHA ETS is all about, it implicates employers with 100 or more employees. It requires employers to prepare, implement, and enforce written policies, either choosing to mandate COVID-19 vaccinations or provide a testing and masking option. It also prescribes paid leave. However, since then, a lot of stuff has happened, and that's kind of what I wanted to give you an update about today. Next slide, please. So I kind of thought I'd try to put this in some sort of trajectory or life cycle. It's a little more complicated, I think, than the life cycle of a caterpillar. But September 9th, President Biden announces that OSHA will issue an emergency COVID rule. And on November 4th, OSHA announced that the rule will be published the next day. It was published on November 5th. And then we just hardly had time to process this rule when the Fifth Circuit stayed the rule, citing grave statutory and constitutional issues. There was a lot of back and forth between the two parties, and then on November 12th, the Fifth Circuit affirmed its decision to stay the ETS. OSHA was ordered to take no steps to implement or enforce the ETS until further court order. And that is a nationwide impact. So does this stay apply to all employers who have 100 or more employees? Yes, it does. But things are about to could change as well. And that's what I wanted to give you an update on. The Fifth Circuit use terms like this is a fatally flawed ETS, or it's a one-size-fits-all sledgehammer, or the ETS is staggeringly overbroad in terms of discussing it in its order. what's going to happen is today on November 16th, just because there are so many lawsuits that have been filed, there is a specific process that will be followed to hold a lottery to draw the circuit court that will hear these consolidated cases. And I'll talk a little bit about that process in the next couple of slides. Next slide, please. So OSHA's statement on its website is that it stated that it will take no steps to implement or enforce the ETS until further court order. It remains confident that it has the authority to protect workers in emergencies. The Fifth Circuit had actually stated, well, OSHA took a long time or delayed in issuing this ETS. So that kind of undercuts the fact that there is actually an emergency and there is actually a grave danger. It's kind of like asking OSHA, well, why did you take so long? This was where did you lose me, I guess, is my question. Okay, so OSHA did kind of make a statement stating that while it's going to be taking no steps to implement or enforce the ETS until further court order, it continues to remain confident that it has the authority to protect workers in emergencies. So one of the things that the Fifth Circuit had stated in its order was that, well, OSHA, if this was an emergency and everyone was in grave danger, why did you take so long to come up with this ETS? Kind of undercuts the argument that there was, in fact, an emergency. Next slide, please. So today is the day, November 16th. We get to find out who gets picked. Every single court, and honestly, I checked the JPML docket today, and I found that the 10th Circuit has also submitted is also part of this kind of list. So the 1st through the 11th and the DC Circuit courts are implicated. So what the Judicial Panel on Multi-District Litigation will do is it will pick a circuit court from a drum containing an entry for each circuit. So once that court is picked, all of the consolidated cases will be heard by this particular court. And so what happens? Next slide, please. OSHA could request that the stay be lifted, and the court may choose to vacate the stay or not. I mean, the court could decide, well, we can keep this stay on the ETS, we could modify it, or we could just throw it out. And the Supreme Court could also be asked to weigh in. So there's a lot of kind of change that we're going to kind of have to keep up with. So stay tuned and we'll keep you posted. But I think the burning question is, next slide, please, is like, should we keep preparing for the ETS? Like, what do we do? There are so many decisions. I mean, there are multiple avenues that you could take. You can wait and see, to decide, well, will the court throw this out? Or you can prepare for December 5th, 2021 or January 4th, 2022 deadlines as prescribed by the ETS. But here's what I will tell you. These decisions are real decisions. They impact real people. And in times of ambiguity, it is your role to kind of step up and decide how you want to kind of strategize on proceeding in the face of ambiguity. So what I recommend is that you consult with internal management, decide what is it that you want to do? How do you want to communicate in times of uncertainty with your employees? Speak to your legal counsel and talk about how you need to frame this communication. How do you need to kind of stay on top of this? I believe employees look to you in times of ambiguity, and it's important to kind of thoughtfully make those communications. So remember that something that you promise or you say today to appease an employee could come back to kind of haunt you later on. So you want to be thoughtful about that. So that's kind of like what I want to leave you with. You have to decide what your organization's threshold is, and you want to move forward on in terms of that. So that's kind of pretty much it in terms of what I have in terms of an update. We'll find out more today on what court gets picked, and I guess stay tuned. This will probably be something that you'll be hearing from us in the near future. And thank you, everyone.
Thank you so much. That was great. And thank you for all your hard work keeping us all updated on this really interesting process and multi-district litigation. And it's very exciting. You make a great point about, what do we do? I mean, we give the updates, but at some point it's the question we're all facing with all these mandates is what do we do at this point, given these challenges, given where we're at with the updates? And I do agree. I think it is, in some cases, a lot of them, it's going to depend on, how risk averse are you, how prepared you can be, how fast you can turn and implement these things if need be. So it's a decision you're going to have to make for yourselves. I do recommend that you, consult with legal counsel if you have questions about it. I think for a lot of clients, there are preliminary steps that can be taken to kind of put them in the best position they can be should this go into effect without rolling it out to all your employees and telling them they have to have, a vaccine by a certain date. But there's steps you can take to kind of gather your own information, take a look at the template policies that are there, get in touch and get a sense of what steps you would need to take to prepare all this. So that's a great point about, assessing where you are personally as an organization and where your folks are, and to make those considerations and to put you in the best place possible as this develops, and stay tuned on that front. One question we had in the chat, and there are a lot of great questions, but this one I wanted to ask. So the decision on November 12th, does that mean, have we seen any indication that the deadlines will be pushed back or reevaluated by further court order? Do we have any sense on that update?
Well, it stayed for now. So OSHA had stated that it's not going to be planning to enforce this. So for what it's worth, I think, they've made that announcement, and we kind of have to hold them to it. But again, things could change in terms of how fast this thing moves. So there's some uncertainty there. You don't know what's going to be happening between now and December 5th. Again, you're absolutely right, Katie. I think it's more about take a look at the ETS policies, the templates. Think about how you want to proceed with it. Map out how you're going to be gathering all of the information that the ETS requires you to kind of collect. Think about how you're going to be communicating with employees who are anxious and coming in to your office and saying, hey, what's happening? Have we decided on what policy we're going to pick? So think about how you want to communicate in that regard, and kind of prepare and get your senior managers and leadership focused on, well, what do we want to do? The last thing we want is December 4th comes along, or maybe even December 23rd, I don't know, whatever that date is, right around the holidays, and you find out that you now have to implement a policy, and you don't want to do that. And I don't think anyone on this chat would ever do that, but you don't want to leave it for the last minute. Like I said, your decision on what you want to do and what route you want to go really makes an impact on real lives and, real people. So.
Yeah, thanks so much. That's the holiday present that nobody wants, right? Surprise, you need to do an entire policy and rollout right now. Okay, great. Thanks so much for that. So to talk yet about another vaccine mandate update, Stephanie Fedorka is going to give us an overview of where we stand in the federal contractor vaccine mandate, which I know a lot of you have been asking about. Go ahead, Steph.
Thank you so much for having me on again. I'm going to give a quick recap of where we are at with the federal contractor mandate. A little bit of an update, but not a whole lot to report on. So quick recap, Executive Order 14042 was signed by President Biden on September 9th, and that was the Ensuring Adequate COVID Safety Protocols for Federal Contractors order. And ultimately what that order does is it directs agencies to incorporate a new clause that will bind contractors or covered contractors to certain Safer Federal Workforce Task Force, quite a mouthful, guidance that includes that vaccine mandate. So on September 24th, the Safer Federal Workforce Task Force issues that guidance. Recently, just last week, it was updated. So there's a little bit of an update that we'll cover. The federal contractor guidance boils down to 3 requirements for covered contractors. First is that COVID-19 vaccination of covered contractor employees. It does recognize limited circumstances where an employee is legally entitled to an accommodation for medical reasons, sincerely held religious beliefs. It also recognizes legitimate delays for vaccination as well in the guidance. The second piece is compliance by individuals, including covered contractor employees and visitors, with respect to certain masking and physical distancing requirements while in covered contractor workplaces. And then the third is covered contractors must designate an individual or individuals to coordinate the COVID-19 workplace safety efforts at their covered contractor workplaces. So that's someone who's monitoring developments, keeping up to date with this Safer Federal Workforce Task Force guidance, making sure that the safety protocols are being followed as well. There's a Phasein. Ultimately, the executive order directs federal agencies to incorporate this new clause as follows: in new contracts awarded on or after November 14th, in new solicitations for contracts or covered contracts issued between October 15th and November 14th, in extensions or renewals of existing contracts, and orders awarded on or after October 15th, and or in options on existing contracts and orders exercised on or after October 15th. And that's important because ultimately a covered contractor is not going to be subject to this guidance until they're actually a party to a covered contract, which means that this new clause needs to be in that contract or contract-like instrument. So what is covered exactly, or what's a covered contract? This applies to any new contract-like instrument, which we'll talk a little bit about, new solicitations for a contract or contract-like instrument, an extension or renewal of an existing contract or contract-like instrument, and exercises of an option or an existing contract or contract-like instrument if it's one of these 4 categories: a procurement contract or contract-like instrument for services, constructions, or leasehold property and leasehold interest in real property, a contract or contract-like instrument covered by the Service Contract Act, a contract or contract-like instrument for concessions, or a contract or contract-like instrument entered into with the federal government in connection with federal property related to offering services for either federal employees, their dependents, or the general public. There are some very specific exclusions to that. But before we dive into that, contract or contract-like instrument, which I said several times in the previous slide, is very broad, and it's defined very broadly in the guidance. It follows the definition in the proposed rule from the Department of Labor regarding increasing the minimum wage for federal contractors. And this is just a snippet of that definition, but ultimately it covers everything from purchase orders, notices of orders, job orders, service agreements, lease agreements, cooperative agreements. So even if it's not as clear as a contract may be, these provisions may be tacked on to a purchase order that you may see included with all those other FAR clauses that you may have to follow as well. The executive order clearly states that it does not apply to the following types of contracts or things that we may think of: grants, contracts or contract-like instruments or agreements with Indian tribes under the Indian Self-Determination and Education Act, contracts or subcontracts that have a value equal to or lesser than the simplified acquisition threshold, which is currently $250,000, employees It does not apply to employees who perform work outside of the United States or its outlining areas, or subcontracts solely for the provision of products. So that's kind of where that line is drawn. However, note that agencies are encouraged by the guidance to exercise discretion, and they're given discretion to incorporate the clause into contracts that are not otherwise explicitly covered by the order, or before they're even required to do so. So early on, we set forth a phase-in, and after those, once those phase-in deadlines hit, the agency is required to incorporate the clause. But like I said, they have discretion in the guidance in the order to incorporate the new clause into contracts that are currently being performed or that are not directly covered by the order even before they have to. So what exactly is required? For the vaccine mandate, covered contractors must ensure that all covered contractor employees are fully vaccinated for COVID-19. And we'll get to that deadline on the next slide. Who exactly must be vaccinated? The guidance states that all covered contractor employees must be vaccinated. And the guidance defines covered contractor employees as any full-time or part-time employee of a covered contractor working on or in connection with a covered contract or working at a covered contractor workplace. But it also includes employees of covered contractors who are not themselves working on or in connection with the covered contract. So it's pretty broad. I think a reasonable interpretation is that if there are any individuals in the workplace that are working on a covered contract, then that workplace itself, all those other employees will be covered by this guidance as well. So by when? Originally, the deadline was December 8th, that individuals, that covered contractor employees needed to be fully vaccinated. Then they said it was January 4th. The most recent guidance has clarified that covered contractor employees must be fully vaccinated by January 18th. So that's the fully vaccinated definition that we've referred to several times before. It's the CDC definition of 2 weeks after your last dose, either that first dose in a 1-dose series or the second dose in a 2-dose series. So that means that ultimately an individual who is not vaccinated would have to have their second vaccine no later than January 4th to meet that January 18th fully vaccinated deadline. After that date, if there's new contracts that are entered into or the clause is incorporated after that date, then all covered contractor employees must be fully vaccinated by the first day of the period of performance on a newly awarded contract or where it's an extension, renewal, et cetera, once that clause has been incorporated. It's important to note that other safety protocols and the guidance must also be adhered to, and those are not necessarily covered by this January 18th deadline. Those, once that clause is incorporated, should be implemented. Contractors working at federal work sites are also going to be required to comply with specific safety protocol, which may include wearing masks, social distancing, showing proof of vaccination, et cetera. So a couple of FAQs. Is there a testing opt-out for this federal contractor vaccine mandate? No, the option is either be vaccinated or unless there is a reasonable accommodation that can be granted for medical or sincerely held religious beliefs, as entitled to by applicable law. Does the federal contractor guidance recognize accommodations? Yes, but again, only for those recognized under the law, such as those for medical or disability or sincerely held religious beliefs. Like I stated, the guidance does recognize that there may be legitimate and medically recognized reasons for a delay of vaccination. And there is some helpful guidance on the Safer Federal Workforce Task Force website, and I will share that link with you all in their FAQs to address those legitimate reasons and what to do in the event that a delay may be appropriate. Ultimately, these types of requests must be evaluated on an individualized basis. Do contractors have to flow down the new clause into subcontracts? Yes, until the subcontract is solely for the provision of products. That's where that line is drawn. But if you are a contractor who is subject to this new clause, then you are also responsible for flowing down that new clause into subcontracts. Do employers have to immediately terminate employees who are not fully vaccinated by January 18th, 2022? The most recent guidance also suggests that there is a little bit of flexibility here. It's not meant to be a cliff. There is some guidance on recommendations of how to treat those individuals who are not yet in compliance. So the guidance seems to suggest flexibility for education, counseling, then followed by, perhaps appropriate discipline in accordance with whatever procedures you have in place, or if there's collective bargaining agreement. But there is some helpful guidance. Again, it seems to indicate some flexibility for what to do if there are individuals who are not compliant by January 18th. Don't forget, like I mentioned earlier, the guidance also includes certain safety measures that covered contractors must comply with. Generally, here's some of the highlights from the guidance. You must ensure that all individuals and visitors comply with the published CDC guidance for masking and physical distancing at the covered contractor workplace. It notes that in areas of high or substantial community transmission, all individuals, including those who are fully vaccinated, must wear masks in indoor settings with limited exceptions, for example, eating and drinking, and a few others that are highlighted and explained in the guidance itself as well. Fully vaccinated individuals do not need to physically distance, however. It does also state that covered contractors must check the CDC COVID-19 tracker. That's that county map with the different levels of community transmission, at least weekly, to determine proper workplace safety protocol with respect to the masking and social distancing, et cetera. It does note that even in situations where the transmission reduces from a high or substantial level to moderate or low, in order to lessen or reduce those safety protocols, there must be, the level must remain at that lower level for at least 2 consecutive weeks before you can say individuals who are fully vaccinated don't need to wear masks. So keep an eye on that. If you have questions, certainly consult with legal counsel with respect to what your obligations may be in that, with respect to this portion of the guidance. And then lastly, that third prong as well, don't forget to designate a person or persons to coordinate implementation and compliance. That individual may be the same individual or maybe a common individual who has been on top of this since March of 2020, but it certainly is an affirmative obligation here under this guidance as well. They must ensure that information on required COVID-19 workplace safety protocols are provided to covered contractor employees and other individuals likely to be present. There's some information about how that can be communicated. Email seems to be okay, websites, memoranda, flyers, or other means. They have posting signage as well as another example. It includes communicating workplace safety protocols and requirements relating to masking and physical distancing at the present, for individuals who are present at the workplace as well. And making sure this individual is also responsible for making sure that the guidance and protocols are complied with respect to showing proper vaccination documentation, which is pretty specific in the guidance, as well as to what exactly an employer needs to review or see or retain to confirm vaccination status. Lastly, just legal challenges. The federal contractor mandate has also unsurprisingly been challenged. I think the latest I saw was about 19 states. As of yesterday, the Attorney General for Texas sued on behalf of the state of Texas and is requesting a temporary restraining order. I have not seen anything yet on a TRO in place, so wait and see. We will surely keep you updated on any challenges and where this federal contractor mandate may lie. But for now, if you have questions about whether or not you are covered or whether or not, what the interplay is between or among all of the vaccine mandates, certainly reach out to your favorite attorney and seek legal counsel, because these things are surely not easy and quite convoluted in several regards.
Thanks so much, Steph. It seems to be a recurring theme for us, probably here and in previous weeks as well. Just wanted to point out to everyone, we put a couple links in the chat box that some folks have been asking for or available. Steph, one question I've seen come up, I know clients have asked me this too, Has there been any revision to the definition of fully vaccinated to account for booster shots? We're seeing this concept of, booster shots, and the eligibility is all over the place and it's varying, and Katie's probably going to give us an update on that, but has that been revised at all to account for that, the definition of fully vaccinated?
Yeah, I don't believe so. I have seen some guidance out there. To be honest, I don't recall if it was the OSHA guidance or the federal contractor guidance, but the definition of fully vaccinated is just that it's the primary series, I think they refer to it as, or the primary dosage, which is either the 2 Pfizer, 2 Moderna, or the 1 Johnson & Johnson. I have not seen that definition be altered yet. So I think for now, fully vaccinated is just those 2 or that 1, and it still is consistent with the CDC, notwithstanding eligibility for potential boosters, but that may be subject to change. I wouldn't be surprised.
Thanks so much. Okay, and last but certainly not least in our program, we have Katie Anderson to give us the update on what's been going on in Albany.
All right, as always, thank you everyone for joining us today, and let's go over this. You can see something here that I'm not going to like. It's that big spike in COVID cases in New York State that's been happening over the past 2 weeks. I've seen a lot of questions about the HERO Act in the chat, and based on these numbers, I think we're looking at the HERO Act being extended into January at the very least. Given that we are not going down, we are going the opposite way. 42% rate of change over the past 14 days does not spell good news for what's happening in New York. So keep your eyes out. Again, as always, really be looking at what's happening here, because this is directly related to whether or not the HERO Act will be continued into at least another month. I just pulled up the CDC statistics about New York State. New York has a community transmission level of high, which is the highest level that you can have. So again, it looks increasingly likely that the HERO Act is going to be extended. Where is the outbreak centered in New York State? Really, the southern tier has a lot of outbreak happening there, Western New York, and then getting into the Capital District and Northern New York. Downstate continues to have the lowest rates of transmission, and that is, good news. Obviously, we have an enormous number of people that live there, but also you look at that pocket in central New York that has been able to remain pretty low, which is also very good news. So I wanted to pull up this map to show you what's happening. Pretty much every state in the US right now is at a high rate of transmission, except for the Southwest. There's a few reasons for this. I could speculate on them all day, but my favorite speculation is when you're done with this presentation today, go ahead and go pull up a weather map and look at the temperatures that have existed over the past 14 days in the areas where you're seeing an increased rate of transmission. It has become cold in the Northeast, and so more people are going inside and resuming indoor activities. We know that this disease loves to be indoors and loves to spread indoors. Additionally, you look at the South, they had a high level of natural immunity that they gained over the summer. They have 90 days of protection because of that if they are not vaccinated. So those things tend to lead to lower transmission rate. Not great news going into the holiday season in the Northeast. Looking at our vaccination progress, though, we've seen every single one of these numbers tick up by 1%. Again, at this point, there's nothing that tracks kids in the age group 5 to 11 in terms of how many vaccines they've received in New York State. But this is good news. We also don't have tracking in New York at this point about booster shots, how many people have gotten a booster shot. But speaking of booster shots, don't worry, I've got lots of news. New York City, can we go back to the other slide, Kathy? Thank you. In New York City, it was announced that any adult who wants to get a booster shot can go receive a booster shot, despite what the federal government has said about having these certain qualifications to receive a booster shot. You need to either live in a high-risk area or work in a high-risk area. The governor, in fact, said any adult who feels that they are at risk should go receive a booster. and basically is urging healthcare providers and vaccine providers not to really be questioning people about their eligibility to receive a booster shot. If they feel at risk, they should go be at risk. Erie County, it's the same thing. The county executive also said, we are really encouraging everybody who can go receive a booster shot to go receive a booster shot. We are not going to be pushing for, why are you eligible, to show that proof. So they are widely available. You can go receive any of the booster shots. So the governor signed 68 bills over the past week. So I'm going to run through a few of them for you because, yes, while we do have lots of COVID-centric news, we've got lots of that. We also have regular governing occurring. And there are big changes that are occurring with that regular governing. This bill was signed. It requires private employers to issue a written notice of electronic monitoring to their new hires, and also to put out a notice in a conspicuous place about the types of electronic monitoring that occur. Now, peep the effective date there. Effective date is May 7th, 2022. So we have a while before this goes into place, but know that this is coming. What does it do? Again, it requires that notice. It requires new hires to be notified about what types of electronic monitoring are occurred. What's considered electronic monitoring? It's monitoring or intercepting telephone calls, emails, or internet usage by an employee on any electronic device. So if you have software installed on your employee's phone, that may qualify if you're tracking what they're doing on that phone. It does not apply, though, to processes designed to manage the type and volume of calls or emails or internet usage for security reasons or computer maintenance. So we're still trying to get clarification on a lot of this. This is, the law was written in a pretty vague way to say, you know, what does that mean? I'm sure is the question for all of you. In our basic reading of this law, it is, you know, looking at your firewalls that you have up. That's not something that is required to be monitored. But if you're having a tracker following your employee from every social media site that they're on, you know, when they're on a work computer, that would be electronic monitoring. And that would need to be something that is, notice would need to be provided in a conspicuous place for that. There is Attorney General enforcement. It is $500 for the first offense and $1,000 for the second, and $3,000 for any subsequent offenses. Don't worry, I am almost 100% confident that Bond, Schoeneck King will be covering this new law in more depth the closer that we get to May. Let's get through OSHA, this OSHA rule before we try to add anything new, right? But don't worry, there are more rules for other people. So that last one applied to private businesses. This one applies to public bodies. This is about the open meetings law. Public entities subject to the open meeting law must post the minutes from a public meeting within 2 weeks of that meeting, and minutes from an executive session within 1 week of that meeting. What constitutes an acceptable minute? Right? It's not, you don't have to have somebody going through and transcribing everything. An unabridged video or audio recording counts. So if you're recording the meeting, you post it on the website, that counts as, you know, posting the minutes of the meeting. An unabridged written transcript also counts under this law. But one thing to note, this only applies to public bodies if they maintain a regularly updated website and they utilize a high-speed internet connection. I'm not, you know, that's quite the exception to cut out there by the state legislature. I am not quite sure where a high-speed internet connection wouldn't exist for a public body, but that may be the case. So if you do not have a website that's regularly updated, then you would not necessarily have to comply with this. But if this complies to you and you're worried, get in touch with one of your, you know, favorite bond attorneys to discuss. Again, this law takes effect immediately, and it was signed on November 8th, so last Monday. So meetings that occur between then, you know, it's ever since the 8th, you have to be complying with this law about posting those minutes within either a week, if it's an executive session, or within the 2-week period if it is just an open meeting. Don't worry, we have a few more bills to go through. Blocking robocalls. I included this because I'm so sick of getting a robocall, and I'm sure you all are too. This law now, it takes effect immediately, requires phone providers to block calls from invalid numbering plans, valid numbers that were not allocated to providers, so a number that was not allocated to Sprint, for example, or a valid allocated number that's not been selected for use. Those are a lot of things that, hopefully we'll be able to cull the herd in terms of the amount of robocalls that we get. And finally, we have nonprofit donor disclosure protections. This bill was also signed last week. It takes effect immediately. So it applies to 501c3s that file an annual financial statement with the Charities Bureau. They no longer need to file that same statement with the Department of State. So it's removing a filing requirement. Additionally, 501c3s are prohibited from publishing financial disclosure records, including the name, addresses, or telephone numbers of donors and the amount donated. That is for privacy concerns. But big but here does not apply to lobbying or political contributions. So that's why I said 501c3s, 501c6s, get in touch with Bond and we'll be happy to discuss. And with that, I am done. So kicking it back to you, Katie.
Thanks so much. Just as I was about to internally complain about all the new laws that are thrown at us, you go with the robocalls. I mean, the relief I'm anticipating with this, I get a call almost daily, I think, about my car's extended warranty. So that would be a nice little development and update. Thank you for all that, Katie, as always. Thank you, everyone, for joining us today. Thank you to all the panelists for the updates. Please stay warm and stay safe. Take care.